What if you file a claim under the Jones Act and the court ultimately determines that you're not a Jones Act seaman? My name is Tim Young. I'm a maritime attorney in New Orleans, and our office handles exclusively Jones Act and maritime injury cases on behalf of injured maritime workers. We've helped hundreds of injured maritime workers over the last few decades. If you're in a gray area where you're not certain whether or not you're going to qualify to be a seaman, and a lot of times companies will begin to pay an injured worker longshore benefits. So you may be receiving a check that says temporary total disability on it, or TTD, and it may be for roughly 2/3 of your average weekly wage. If you're getting that check, there's a lot of situations where you may actually be qualified as a Jones Act seaman, where you could actually go into court, file a suit under the Jones Act, and try to collect many more damages, including pain and suffering and full loss of future wages, as well as full medical expenses into the future. A lot of our clients will ask us, what happens if I do elect to do that, go into court, file a Jones Act case, and ultimately the judge or the jury determines I was not a seaman, I was not a vessel worker, and instead I did fall under the Longshore Act. Well, the great news for you is it does not cost you any of your rights or any of your remedies under the Longshore Act. If you go into court and you file a case as a Jones Act seaman, and the judge or the jury later determines that you don't fall under the Jones Act, and in fact you should have been a longshoreman and you're a longshoreman, you should receive those rights, you're not penalized at all. You don't lose your right to longshore benefits, you don't lose your compensation and medical that you can receive through the Department of Labor. You simply have your Jones Act case dismissed and all of your rights continue under the Longshore Act. So it's not a choice where you've got to make an election and if you're wrong, you're penalized. A lot of times we encourage our clients to go ahead and file a case as a Jones Act case. There may be issues of fact and you may actually qualify as a seaman, and you may collect a lot more money if you do. And if at the end of the day the court or the jury decides differently, you simply are back into the original position where you started, which was receiving longshore benefits. Call us if you have any questions at all about whether or not you can file a case under the Jones Act, and we're happy to discuss with you again how there's really no penalty if you do file a Jones Act case and later on it's determined that you're simply a longshoreman.